They say the law is supposed to protect your rights, but what happens when that same law draws a line in the sand and tells you, you can walk up to this point, but no further? In Florida, that line is the open carry ban, and right now, state officials are asking a judge to keep it exactly where it is. This isn't just a technical legal fight. It's about whether the sight of a holstered pistol on your hip makes you a lawbreaker or a law-abiding citizen exercising your rights. And here's the thing, the decision in this case could echo far beyond Florida's borders. To understand the weight of this moment, we need to go back to where it all began. Florida is often painted as a pro-Second Amendment state. With its concealed carry laws and shall issue permits, it's seen by many as a safe haven for gun rights. But it's also one of the few states that still bans most forms of open carry. Sure, there are exceptions like when you're hunting, fishing, or camping, but for the average citizen walking down the street, your firearm must remain concealed. Violate that, and you're looking at a potential criminal charge. Now, the case on the judge's desk stems from a challenge to that very ban. Gun rights advocates argue it's unconstitutional, a violation of both the Second Amendment and the Florida Constitution's right to bear arms provision. They point to history back to the founding era where carrying a weapon openly was the norm, not the exception. And they ask if the Constitution doesn't specify how you can bear arms, why should the state get to? On the other side, state officials and their legal team are digging in their heels. They're not mincing words. They say allowing open carry would cause public alarm, create unnecessary tension for law enforcement, and disrupt public order. Their argument leans heavily on what they call the public safety exception to gun rights, essentially the idea that even constitutional rights can be limited if the state has a compelling reason. They cite court precedent, including the U.S. Supreme Court's acknowledgement in Heller and Bruen that rights are not unlimited. But here's where it gets interesting. Since the Supreme Court's landmark Bruen decision in 2022, the legal landscape has shifted. The court made it clear that modern-day gun laws must be consistent with the historical tradition of firearm regulation in America. That means Florida can't just say, we think it's safer this way. They have to prove that similar restrictions existed at the time the Second or 14th Amendment was ratified. That's a high bar to clear, and it's exactly why this case matters so much. Imagine, for a moment, you're a lifelong Florida resident, licensed to carry a concealed handgun. You've passed your background checks, paid your fees, and taken the training courses. But one hot summer afternoon, your shirt rides up just enough for someone to see the grip of your pistol. Within minutes, a police officer is approaching you, not because you've committed violence, but because you've committed visibility. That's the reality of Florida's open carry ban. And if the court sides with the state, that reality won't change. If they side with the challengers, Florida could join the majority of states that allow open carry, potentially sparking a ripple effect in other states, still clinging to similar restrictions. Here's why this matters to you even if you don't live in Florida. The legal arguments here are a test case for how far Bruen really goes. If the judge rules that the open carry ban fails the historical tradition test, it could arm gun rights advocates across the country with fresh ammunition to challenge similar laws. And if the court upholds the ban, it might signal that judges still see room for public safety exceptions. Even in a post-Bruen world, we're only scratching the surface of what's at stake here. In the next section, we'll break down the specific legal strategies each side is using and the surprising historical evidence the state is relying on to defend a modern law. The air inside the federal courthouse felt heavy, as though the building itself could sense the weight of the arguments unfolding within its walls. On one side, attorneys for the St. Lucie County Sheriff and state attorney were sharpening their points, determined to defend Florida's decades-old ban on open carry. On the other, lawyers for gun owners of America stood ready to dismantle that very law, brick by legal brick. Arthur Buddy Jacobs, representing Sheriff Del Toro and State Attorney Bacatl, stepped forward. His voice was calm, deliberate, almost surgical. He laid out the foundation of their argument. Your Honor, this case is not about whether Floridians have a right to bear arms, he began, glancing briefly toward the plaintiff's table. It is about the manner in which that right may be exercised. The Second Amendment does not guarantee the right to carry firearms in any particular way. Florida law already allows concealed carry with the proper license. That is more than sufficient to satisfy constitutional protections. He paused to let the words sink in, then continued. The plaintiffs wish to create a constitutional crisis where none exists. They argue that banning open carry violates the text of the Second Amendment. But history tells a different story. The story of states and municipalities regulating the public display of weapons for centuries, consistent with the public good. Across the room, Richard Hughes, the lead plaintiff, sat with his arms crossed, his jaw set. He was a Palm Beach County resident, and while the defense had already questioned his standing in this case, Hughes looked like a man who had no intention of backing down. When it was the plaintiff's turn, their lead counsel rose, a fire in his tone. Your Honor, The right to bear arms is not a privilege to be rationed out in the manner government deems acceptably, is a right guaranteed by the Constitution, and rights do not depend on government permission slips. Concealed carry and open carry are not interchangeable. One is hidden, the other is in the open. The founders understood this distinction. The attorney took a step toward the bench, his voice intensifying. Florida's ban is an outlier in a nation that, for much of its history, respected the open bearing of arms. There is no meaningful historical tradition of banning open carry altogether, and the defense's attempt to rewrite that history is deeply flawed. Judge Jose Martinez listened intently, his expression giving nothing away. The fate of Florida's open carry ban and, perhaps the future of gun rights litigation in the state, now hung in the balance. As the lawyers clashed over constitutional text, history, and public safety, the tension in the room became almost physical. Supporters of both sides sat in the gallery, leaning forward in their seats, barely breathing as each point was made. It wasn't just a legal battle, it was a fight over identity, tradition, and the meaning of freedom itself. Outside the courthouse, news cameras rolled, capturing interviews with activists, concerned citizens, and political analysts. Some held signs demanding constitutional carry now. Others countered with banners reading public safety first, open carry. The rhetoric grew sharper by the hour, as if the walls of the courthouse could no longer contain the intensity of the debate. The legal battle had already spilled into the streets, and by the time the hearing adjourned for the day, it was clear that the war over Florida's gun laws was only beginning. By the next morning, the courthouse steps looked less like the entrance to a legal institution and more like the front lines of a cultural battlefield. Television crews had arrived before dawn, securing prime camera angles. Activists in matching shirts handed out pamphlets. A cluster of uniformed deputies kept watch, scanning the crowd for any sign that the heated words might turn into something more dangerous. Inside, the courtroom felt even more charged than the day before. The plaintiffs were ready to deliver the second wave of their argument, this time focusing heavily on historical precedent. Their attorney approached the podium, flipping open a thick binder. "Your Honor," he began, "the Supreme Court's decision in Bruen made one thing perfectly clear. Modern gun regulations must align with the historical tradition of firearm regulation in this country, and when we examine the 18th and 19th centuries, we do not find a tradition of banning open carry. We find regulation, yes, but not prohibition." He turned a page, his voice unwavering. "What Florida has done is not in line with history. It has taken one method of carrying, method deeply rooted in our nation's heritage, and made it a criminal offense. The state may argue that concealed carry offers an alternative, but an alternative is not the same as a right." The defense counsel rose almost immediately, eager to dismantle the historical claims. "The plaintiffs want to cherry-pick the past, Your Honor. They cite a few instances of permissiveness, while ignoring the long and well-documented tradition of states and municipalities restricting public display of arms to preserve the peace. This is not about rewriting history, it's about understanding it in full." Judge Martinez interrupted for the first time that day, leaning forward slightly. "Counselor, are you suggesting that there is a direct historical analog to Florida's outright prohibition on open carry?" The defense hesitated, choosing words carefully. "Not outright prohibition in the modern sense, Your Honor, but there are examples, numerous examples of significant restrictions. The principle remains the same, regulation to protect the public." The judge nodded slowly, jotting something down. In the gallery, Richard Hughes' supporters exchanged glances. They knew the case hinged on that very point, whether Florida's law could find enough historical precedent to withstand the scrutiny of the Bruen standard. Outside, the conversation was shifting. On talk radio, callers debated whether open carry would make the state safer or turn every public space into a potential flashpoint. Social media was ablaze with clips from the hearing, soundbites from attorneys, and memes from both sides mocking the other's stance. By midday, the courthouse lobby was buzzing again as everyone broke for lunch. The two legal teams passed each other without a word, their eyes forward, their faces masks of professional resolve. But everyone knew the same thing when they returned after lunch. The arguments would dig even deeper, and the fight for Florida's open carry law would be closer than ever to a decisive turning point. The courtroom had grown so quiet that you could almost hear the judge's pen scratching notes on the legal pad before him. He leaned back in his chair, eyes narrowing slightly, as though weighing the weight of history against the letter of the law. You could sense it. This was no longer just about Florida's open carry ban. This was about setting a precedent that could echo far beyond the state's borders. The state's attorney delivered his closing with the sharp precision of a scalpel. "Your Honor, this is not about infringing rights. It is about ensuring that those rights are exercised responsibly. The open display of firearms in public spaces poses an undeniable risk to public order and safety. This is not speculation, it's documented fact." He cited police reports, statistics, and past incidents in which open carry led to misunderstandings. Panicked calls to law enforcement and tragic outcomes. Then came the turn for the plaintiff's attorney. His voice was calm, almost too calm, like a storm gathering strength beneath the surface. Rights that can be hidden, he said, are rights that can be taken. The very essence of the Second Amendment is not to be concealed for the comfort of others, but to be lived openly, without fear of government reprisal. Florida's ban is not safety policy. It is fear policy. And fear, he said, locking eyes with the judge, is not the foundation of freedom. The judge listened without interruption. No facial twitch, no visible bias, just that inscrutable gaze from the bench. But every person in that room knew he was carrying a burden that went far beyond this single decision. Was he willing to be the one to uphold a law many believed was outdated, even unconstitutional? Or would he be the one to break it? Here's where it matters to you. The ruling in this case will determine not only whether Floridians can openly carry, but it will send a message to lawmakers in other states. If Florida's ban stands, it could embolden more restrictions elsewhere. But if it falls, it could trigger a chain reaction of challenges across the country. The judge took a slow breath, then closed the file before him. I will issue my ruling in due course, he said, his voice steady, almost unreadable. And with that, the gavel came down. Court adjourned. Outside, reporters swarmed the steps, microphones angled toward anyone who would speak. Activists on both sides shouted over each other, their words lost in the chaos of the crowd. But somewhere in the middle of all that noise, a truth lingered. This fight wasn't over. It had only just begun, and that's why, if you care about your rights whether you own a gun or not, you need to stay informed. This ruling could reshape the boundaries of the Second Amendment for decades. If you want to keep following cases like this, make sure you subscribe, because when that ruling drops, you'll hear it here first. Because in the battle for constitutional rights, the moment you stop paying attention is the moment they start slipping away.